Big news out of the Supreme Court. The Chief Justice of the United States of America just issued a rare statement on President Trump's call to impeach the judge in his Alien Enemies Act case. I want to go straight to Paula Reed. Paula, wow, this is a very big deal.
This is a huge deal. Here you have Chief Justice John Roberts appearing to push back on statements President Trump made earlier today, suggesting that a judge, James Boasberg, who of course temporarily blocked deportations by the Trump administration, or at least tried to, should be impeached. And here the Chief Justice writes, "For more than 2 centuries, it has been established that impeachment is not an appropriate response to disagreement concerning a judicial decision. The normal appellate review process exists for that purpose." Now, this is, of course, a very short statement, but it says so much, Dana.
Hello and welcome, friends. Adam is here. So what just happened, guys? The floor just dropped out from under American democracy. Not metaphorically, not in some abstract, slow-motion decline that political scientists will analyze decades from now. I'm talking about a single, searing, irreversible moment that exploded across television screens and instantly burned itself into the history books. A sitting justice of the United States Supreme Court, one of the 9 guardians of the constitutional order.
Because earlier today, in a Truth Social post, President Trump sort of went on a tangent about how angry he was at this judge and saying this judge, like many of the crooked judges I am forced to appear before, should be impeached. And this comes just several days after Boasberg tried to temporarily block some deportations by the Trump administration, and the Trump administration did not abide by his order to turn around 2 planes that had already taken off. And in a pretty heated hearing yesterday, the Justice Department insisted that they did not need to abide by the judge's oral order from the bench, something the judge took issue with. And then even when the judge had issued a written order, they still did not comply. And in court yesterday, they were arguing that the reason they did not need to comply with that written order is because they said that President Trump has a broad executive authority when it comes to foreign affairs. And the reason that this whole case is significant, Dana, is because this is not just another test of Trump's expansive use of executive power. It is also a test of the extent to which he and his lawyers believe he can be checked by the courts. So here, Judge Boasberg getting some support from really the most senior justice in the land.
Yeah, your eyes are...
Rose from their seat at a live event, turned their back on the President of the United States, and walked out. Just walked out. In front of cameras, in front of witnesses, in front of the entire world. And the reason they left wasn't a scheduling conflict or a sudden illness. They walked because the president was standing at the podium actively.
Going wide, David Chalian.
It's astonishing. And I don't want to diminish the importance of the specific case that
but this
Paul
is about that.
It is, obviously, but it's so much bigger than that, too.
Yeah.
This is, I just want to step back here, because there are so many people, I think, that said in the last couple days of, well, are we in a constitutional crisis or not? And are they really defying an order? Or let's parse whether it was a written order or a verbal order. It's too early. It's too soon to get worked up about this or concerned about this. And John Roberts, who does not choose to jump into the political fray at all if he doesn't have to, says, no, it's not too soon. I am the guy that sits atop one of the 3 co-equal branches as designed by the Constitution, and it's not too soon for me to say, back off, Mr. President. You should not be talking about impeaching a district judge, a district-level judge, because you don't like the ruling.
Aggressively and unapologetically insulting the Constitution of the United States. Trashing the very document that gives the Supreme Court its power, its legitimacy, its entire reason for existence. This isn't a leaked rumor that administration officials are scrambling to deny. This isn't hearsay from anonymous sources. This is a live, witnessed...
That's not the way the last 2 centuries have worked. And so I think, he doesn't get involved very often. The fact that he's chosen to step in here, you see he's responding to what Trump put in that Truth Social this morning.
Right, which I'll get to in a second.
But also just the aggressiveness to push back on Trump this way, choosing to speak and speaking the way he did in this statement, we should all take note of this moment.
Okay, I'm not sure if we have it yet because we just got it to put up on the screen, but I'm just going to read it one more time, and the it being John Roberts' statement, which we just got a few moments ago. For more than 2 centuries, it's it has been established that the impeachment is not an appropriate response to disagreement concerning a judicial decision.
Undeniable act of judicial resistance that has sent shockwaves through every law school, every courtroom, and every political institution in America. The legal world is in a full-blown meltdown, and for good reason. We have entered a phase of constitutional confrontation that feels less like a political dispute and more like the opening chapter of a catastrophic institutional collapse.
The normal appellate review process exists for that purpose. Okay, now let me catch up our viewers, and you saw it a little bit on the screen, but I just want to point specifically to what this is in response to Donald Trump's post. Here's what Donald Trump said. This radical left lunatic of a judge, a troublemaker and agitator who was sadly appointed by Barack Hussein Obama, was not elected president. He went on to say, I'm just doing what the voters wanted me to do. This judge, like many of the crooked judges I am forced to appear before, should be impeached. Now, before we continue our conversation, I just want to add another layer to this, which is, remember what Donald Trump said just on Friday, which was, I don't know, what, four days ago, when he was at the Justice Department about a different judge.
Let's transport ourselves directly into that room. The atmosphere is already charged with tension. Trump is doing what Trump does, rolling through his speech patterns, feeding off the energy of the crowd, veering wildly off script into territory that makes his handlers flinch. But this time, he's not just attacking the usual targets. He's not just swinging at Democrats or the media or some foreign leader who annoyed him. He's going straight for the judicial branch. He's making claims that his presidential power places him beyond the reach of federal judges, that the courtroom doors are closed to anyone trying to block his agenda, that the Constitution as commonly understood simply doesn't apply to his decisions about immigration or trade or national security. He's telling the country, in essence, that he is the law. And sitting there in the audience, in the sea of dignitaries and officials, is a Supreme Court justice. Someone who has devoted their entire life to the study and application of that same Constitution. Someone who swore an oath to defend it against all enemies, foreign and domestic. And they're listening to the president treat it like a disposable napkin. Then it happens. The justice doesn't make a scene. There's no shouted objection, no dramatic confrontation with security. It's actually far more powerful because of its restraint. They simply stand, gather themselves, and walk deliberately toward the exit while Trump is still speaking. The camera catches it. The room notices it. The symbolism lands like a bomb. A Supreme Court justice physically removing themselves from the presence of a president who is attacking the Constitution is a visual that no amount of spin can erase. This is the institution of the judiciary standing up, turning its back and saying, "We will not participate in this demolition." Supreme Court justices don't do this. They are trained, disciplined, and socialized to be the most restrained figures in American public life. They avoid controversy. They refuse to comment on pending cases. They maintain a studious distance from the political food fights that consume the other branches. Their power depends on the perception of neutrality, on the idea that they are above the partisan battlefield. So when one of them abandons that carefully cultivated posture and walks out on a sitting president, the message is deafening. It's the judicial equivalent of setting off a flare gun in a dark theater. Something is terribly wrong, and everyone needs to see it. And then, as if the walkout itself wasn't enough to shake the foundations of the Capitol, the Chief Justice of the United States enters the fray. John Roberts, a man who has made a career out of speaking as little as possible about matters of political controversy, issued a statement. Not a leaked comment to a friendly reporter. Not a vague remark at a legal conference. A direct, unambiguous public rebuke of the president's behavior. Roberts said, in language that was as pointed as judicial decorum allows, that for more than 2 centuries, impeachment has never been an appropriate response to simple disagreement with a judicial decision. He reminded the country that the appellate process exists precisely for that purpose, that if a president doesn't like a ruling, his remedy is to appeal, not to attack the judge personally, not to call for their removal, and certainly not to threaten the entire edifice of judicial independence. This is Roberts speaking in code, but the code isn't hard to crack. He's essentially telling the president, you are violating the basic norms of constitutional governance, and you need to stop. When the cautious, consensus-building Chief Justice decides he can no longer remain silent, you know the guardrails are being tested to their absolute breaking point. The source of Trump's specific fury is a federal judge named James Boasberg, a name that has suddenly become a rallying cry and a target. Boasberg is a federal district judge in Washington, D.C., an Obama appointee who has presided over cases challenging the legality of various Trump administration policies. And Trump, in response to rulings he didn't like, decided that the appropriate response wasn't to file an appeal or argue the merits of the law. It was to publicly call Judge Boasberg a lunatic. A lunatic. The President of the United States stood before the nation and used that word to describe a sitting federal judge. And then he went further. He demanded Boasberg's impeachment. Not because Boasberg committed a crime or engaged in corruption, but because Boasberg issued rulings that Trump disagrees with. This is a fundamental misunderstanding, a potentially deliberate misunderstanding of what impeachment is for. Impeachment is the nuclear option, reserved for treason, bribery, high crimes, and misdemeanors. It is not a customer complaint box for disgruntled litigants who lost a case. By calling for the impeachment of a judge whose rulings displeased him, Trump is trying to weaponize the removal power as a tool of political intimidation. He's sending a signal to every other federal judge in the country: rule against me, and I will try to have you destroyed. The underlying legal argument that has Trump so agitated is even more concerning than his rhetoric. During these legal battles, Trump and his team have advanced a theory of executive power that is breathtaking in its scope. They are arguing, in court filings and public statements, that presidential authority in certain domains is essentially absolute. The domains they reference, national security, immigration enforcement, trade policy, are not trivial. They are vast, sprawling areas of governance that touch nearly every aspect of American life. The claim is that when the president acts in these areas, the courts have no business second-guessing him. Judges should step aside. Judicial review, the bedrock principle established in Marbury v. Madison, should simply evaporate because the president says so. There is historical precedent for broad executive discretion, particularly in foreign affairs. But what Trump is proposing goes far beyond discretion. It approaches a kind of legal immunity, a zone of executive action where the Constitution's checks and balances don't operate. This is the argument that made the Supreme Court Justice walk out. This is the argument that made John Roberts issue his rare statement. This is not a normal policy disagreement. This is a full-throated assault on the very concept of limited government. And then we have the reported exchange that has legal circles buzzing with a mixture of horror and disbelief. During the proceedings involving Judge Boasberg, there was an extensive back and forth about the limits of judicial authority. At one point, Boasberg reportedly pushed back against the administration's claims of unlimited executive power with words to the effect of, "We don't care. We'll do what we want." Now, those words, stripped of context, sound like a judge admitting to lawless behavior. But context is everything here. Boasberg wasn't declaring that the judiciary is above the law. He was pushing back, forcefully and perhaps with some exasperation, against the idea that the president can simply declare himself immune from judicial oversight. He was defending the essential, non-negotiable principle that courts exist to check executive power. The statement was a declaration of institutional backbone, not an admission of judicial tyranny. But in the current political climate, absurdly, that important distinction is being obliterated. The administration's supporters are already weaponizing the quote to paint the judiciary as out-of-control activists who openly admit they don't care about limits. But the reality is the exact opposite. The judge was trying to uphold limits, and the president was trying to erase them. The entire political and legal establishment is now holding its breath because the Supreme Court's docket is a ticking time bomb of cases that will force these exact questions to be resolved. Multiple major disputes are winding their way through the appellate pipeline, all of them converging on the same fundamental question: how much power does this president actually have? There are cases challenging the legal basis for the sweeping tariffs Trump imposed using emergency economic powers. The core question is whether the president can unilaterally rewrite American trade policy without meaningful congressional input. There are cases about birthright citizenship, where Trump issued executive orders attempting to end the automatic grant of citizenship to children born on American soil to undocumented parents. This directly challenges the plain text of the 14th Amendment, which couldn't be clearer in its guarantee. There are cases about the mass deportation operations, where the administration has been deploying military assets and invoking wartime statutes to remove individuals with minimal due process. All of these cases are careening toward the Supreme Court, and the justices are going to have to decide, in ruling after ruling, where the limits of the presidency actually fall. Here's the excruciating dilemma facing the conservative majority on the Supreme Court. 6 justices were appointed by Republican presidents. 3 of them, Gorsuch, Kavanaugh, and Barrett, were personally selected by Donald Trump. They are ideologically conservative, and in many cases, they likely agree with the policy goals the administration is trying to achieve. But they are also institutionalists. They care about the long-term legitimacy of the court. They know that if they rubber stamp every power grab, they will be remembered as the majority that dismantled the separation of powers. If they side with Trump on every major case, they will confirm the worst suspicions of their critics, that they are not jurists but partisan operatives in robes. If they rule against him, they will face the full fury of the MAGA movement, which will accuse them of being deep state traitors who stabbed their own appointer in the back. John Roberts, in particular, is acutely sensitive to the court's public standing. He has spent years trying to convince the country that the Supreme Court is not just a political body, that its decisions are based on law, not on personal preferences. The attack on Judge Boasberg and the subsequent walkout have made that job exponentially harder. The mask of impartiality is being ripped away by a president who wants the court to be a partisan weapon and by a base that expects total loyalty. The constitutional scholars are not mincing words about the danger we are in. There's a notable article from Stanford that's been circulating widely among academics, and its argument is chilling. It suggests that we are not merely in a constitutional crisis, which implies a singular, acute event that will be resolved. We are in something worse. We are in a state of constitutional rot, a gradual systemic erosion of norms where each new violation makes the next one easier, where the abnormal becomes normal, and where the institutions that should provide resistance gradually lose their will and their power. The argument is that Trump isn't just violating isolated rules. He's changing the baseline understanding of what a president is permitted to do. Every time he attacks a judge and faces no consequence, the next attack becomes more likely. Every time he claims that his authority trumps judicial review and his supporters applaud, the expectation of obedience to the courts diminishes. He is teaching a generation of politicians and voters that the Constitution is a suggestion, not a command. And the scariest part of all this is the boomerang effect that will inevitably occur. Trump will not be president forever. Eventually, a Democrat will occupy the Oval Office, and that Democrat will inherit whatever powers Trump has successfully claimed for the executive branch. If Trump establishes that the president can declare an emergency and levy tariffs without Congress, a future Democratic president will use that exact same power to impose carbon taxes or climate mandates. If Trump establishes that the president can ignore judicial orders on deportation, a future president could ignore judicial orders on gun confiscation or healthcare mandates. The sword cuts both ways. Authoritarian powers claimed by one side become permanent tools for the other. And yet, our political discourse is so tribalized, so focused on winning the immediate news cycle, that nobody seems to be thinking about the long-term consequences. This is precisely why the walkout and Roberts' statement matter so profoundly. The judiciary is fighting for its survival as a co-equal branch of government. Roberts isn't just defending Judge Boasberg because he likes him or because he has some secret policy preference. He's defending the idea that judges must be able to issue unpopular rulings without facing political execution. The justice who walked out wasn't making a statement about tax policy or health care. They were making a statement about the Constitution. They were refusing to lend their presence and their legitimacy to an event where the founding document was being publicly degraded. These are defensive actions by a branch of government that is under siege. It's the institutional equivalent of an immune system mobilizing to fight off a massive infection. But the terrifying truth is that the court possesses very little enforcement power. As Alexander Hamilton noted in Federalist 78, the judiciary has neither the purse nor the sword. It controls no army. It commands no budget. Its power rests entirely on the willingness of the other branches and the public to obey its rulings. If a president, backed by a substantial portion of the population, simply decides to ignore a Supreme Court decision, there is very little the court can physically do about it. The U.S. Marshals theoretically enforce federal court orders, but they answer to the executive branch. If the president orders them to stand down, the enforcement mechanism evaporates, and we are left with a paper victory and a constitutional vacuum. So where does this escalating confrontation lead us? The Supreme Court will eventually have to hand down rulings on these blockbuster cases about tariffs and immigration and emergency powers. Those rulings will either reaffirm the constitutional boundaries of the presidency or they will validate Trump's expansive vision of executive supremacy. Given Trump's behavior, it is almost impossible to imagine him graciously accepting a ruling that goes against him. He will do what he has done to Judge Boasberg. He will attack the justices personally. He will call them names. He will tell his supporters that the fix is in, that the deep state is strangling the will of the people. And then the real test will begin. Will the administration comply with a court order it doesn't like? If the court rules that a particular deportation policy is illegal, will the deportation flights stop? Or will they continue under some new creatively crafted justification? If the court strikes down a tariff regime, will the Customs and Border Protection computers be reprogrammed to stop collecting the money? Or will the administration simply slow-walk the compliance until the ruling is effectively meaningless? We are heading into the kind of showdown that the framers dreaded, a direct collision between a president determined to wield maximum power and a judiciary trying desperately to hold him to account. Let's pull back and examine what this all means for the average American who isn't steeped in constitutional law or glued to the daily drama of the courts. The foundational promise of the American system is that no single individual gets to be the king. The entire revolutionary project was a rejection of concentrated, unaccountable power. The checks and balances were designed to slow things down, to force deliberation, to prevent any one branch from steamrolling the others. That system only functions if the players accept that losing in court is part of the process. The president doesn't have to like every judicial decision. He's free to criticize the reasoning. He's free to file an appeal. But if he crosses the line from criticism into intimidation, if he starts treating judges as enemies to be destroyed rather than neutral arbiters to be respected, the system stops working. When the president says that his authority to protect the nation means courts must be ignored, he is, whether he fully realizes it or not, laying the intellectual groundwork for authoritarianism. The definition of a constitutional democracy is that the leader is subject to the same laws as everyone else. If the leader is above judicial review, if he can brush aside court orders with a wave of his hand and a fiery tweet, then the law is no longer the law. It's just a set of suggestions that apply only to people without power. The response from Trump's political base is a fascinating and deeply troubling window into how much the public's relationship with democratic norms has changed. His supporters see these attacks on judges not as a bug of his presidency, but as a feature. They voted for him precisely because they want him to tear down the existing system, which they see as hopelessly corrupt and biased against them. To them, Judge Boasberg is not a neutral arbiter of the law. He's an Obama-appointed political operative wearing a robe to disguise his partisanship. When Trump calls him a lunatic and demands his impeachment, the base cheers. They see it as a strong leader finally standing up to an unelected cabal that has been running the country behind the scenes for decades. There is a kernel of legitimate frustration embedded in this worldview. The federal judiciary has expanded its influence over policy dramatically. Judges do sometimes overreach. The judicial confirmation process is a broken, hyper-partisan nightmare. But the solution to judicial overreach cannot be the complete annihilation of judicial authority. That's not a cure. That's a bullet to the head of the patient. The proper response to a judge whose rulings you don't like is to win elections, confirm better judges, and argue your cases persuasively on appeal. The response cannot be to threaten the personal safety and job security of anyone who rules against you. As we stare down the barrel of a constitutional arms race, it's worth naming the scenarios that lie ahead so we can recognize them when they arrive. The best-case scenario, and the one that seems increasingly naive, is that the Supreme Court rules against Trump on some of these major cases, and the administration, after some grumbling and rhetorical firestorms, actually complies with the decisions. The planes stop flying. The tariffs get reprogrammed. The system bends but doesn't break. We move on, scarred but intact. This scenario requires a level of restraint Trump has never shown. A second, much darker scenario is that the court rules against Trump and the administration refuses to comply. This is the Marbury versus Madison scenario all over again, the nightmare where the executive branch just ignores the judicial branch. The court would issue a ruling and the administration would essentially say, "Come and enforce it." This would trigger a legitimacy crisis unlike anything since the Civil War, forcing a choice between the rule of law and the reality of power. The third scenario is that the Supreme Court, perhaps through a mixture of ideological alignment and intimidation, sides with Trump on the major cases. This would enshrine a massive expansion of executive power into constitutional precedent. The presidency would become a fundamentally different office, far more powerful and far less constrained than the one designed in 1787. The long-term consequences of that would be irreversible. The walkout, the Roberts rebuke, the attacks on Boasberg, these are not separate stories. They are a single, interconnected narrative of systemic breakdown. The Supreme Court justice who walked out was sending a message that they will not normalize the president's behavior. They will not sit quietly and pretend that trashing the Constitution is just another Tuesday in American politics. They are defending the integrity of their institution. But they can't defend it alone. The ultimate fate of this conflict depends on factors beyond the courtroom. It depends on whether members of Congress, particularly Republicans who have influence with the administration, decide that the survival of the judicial branch is more important than their next primary election. It depends on whether the American people, across the political spectrum, can recognize that the principle of judicial review matters more than any single policy outcome. It depends on whether we still have a collective commitment to being a nation of laws, or whether we have quietly decided that we'd rather be a nation of men, led by a strong man who promises to deliver for our tribe. The history books are watching us. The chapter is being written right now. The question is whether the final sentence will be one of resilience or one of collapse.